We about to start though.
I will start with a direct comment on my competitor's comment on my case, in that she said that did not create the end-all be-all that Congress was supposed to have. I will note that Gibbons v. Ogden was on commerce alone and did establish significant power in that area. With that being said, I'll move on. The vote in Furman v. Georgia was split 5-4 in favor of Furman. The justices ruled that the death penalty was unconstitutional, but of the 5 justices in the majority, only 2 agreed that it was unconstitutional in every circumstance. The fact that they could not reach a conclusion led them all to submit, all 9 justices to submit an individual statement. The justices in, this led to an incredibly vague and incredibly weak conclusion, reducing influence immensely. Confirming this is the fact that 35 states today have the death penalty. In 2010, there were 1,226 people executed by capital punishment. Weigh that at the over 300 million people in the United States, and the number that comes out is 0.0004% of people in direct influence. Both of these speak to the little effect of the justice's decision truly made over what is ultimately a vast minority of the country. To accent that point, you may recall the 2005 court case, Roper v. Simmons, that ruled the executing of minors as cruel and unusual punishment. A point I believe most of us here will agree with. Since 1976, there have been 22 juveniles executed. Due to the fact that the Supreme Court never passed a definitive decision. In Furman v. Georgia in the first place, 5 years preceding that 1976 mark. It took an additional Supreme Court case to supply the necessary authority to declare even part of capital punishment unconstitutional. It took another Supreme Court case yet to declare that execution of mentally disabled peoples was unconstitutional. The 2002 court case, Atkins v. Virginia. In addition, today, after 3 court cases and more besides, capital punishment is still thriving in those 35 states. How many tries has it taken? 3. Has it been effective? No. How many tries did Gibbons v. Ogden take? 1. And it still is in effect to this day. The argument for Washington v. Glucksberg thus far has been based on the fact that the Supreme Court's ruling was overturned by the states in a truly rare circumstance, modeling that the people and the states can generate influence over the Supreme Court. Though at first it seems like a revolutionary occurrence, it was not very definitive and did not have what one would call widespread influence. Out of 50 states, only 2 have legalized physician-assisted suicide, in agreement with the overturned decision. 2, ladies and gentlemen. What was first viewed as a great exception is illuminated as not much more than a local decision on a local law. That affects an incredibly small portion of the population. An estimated 52 people annually, over the 300 billion. That is 0.00004%. However, it's not entirely relevant. From the point of view of my fellow competitor, it is the state's overturning of the law that had influence. Doesn't that essentially show us that the original Supreme Court case itself never had much influence in the first place? The Supreme Court's decision lasted a glorious 11 years before the states overturned it. This as compared to Gibbons v. Ogden, which has had a lasting effect for 187 years and counting. We see parallels between this case and Furman v. Georgia. Limited area of impact, unclear results, people ultimately doing what they want to anyway. 0.0004% of the population directly affected by the death penalty. 0.00004% of the population directly affected by physician-assisted suicide. Ladies and gentlemen, with that in mind, I ask you, how many of us are directly affected by commerce? Every single last one, 100%. With this, which case is in direct correspondence with the maintenance of our government, and by effect, our country as a whole? Yes, Gibbons v. Ogden. The case that expanded the powers of Congress to influence trade. What started as something as humble as 2 men quibbling about who would get to send their steamboats across the harbors of New York ended up expanding to the 20th and now the 21st centuries. How much power does Congress get? A fundamental question. And never once, ladies and gentlemen, Let it slip from your minds that this power is wielded to maintain the inner working framework of our nation. The inner working framework of our nation, one that was so well thought out and revolutionary that dozens of existing models exist elsewhere in the world today. And all of it comes back to the nation's spine, the three Montesquieuian branches of government, in court cases such as Gibbons v. Ogden that established our nation's framework. Gibbons v. Ogden greatly affected how our nation functions in trade from state to state by expanding Congress's power. Between this, the power to regulate budget, and the supremacy clause, Congress gained the power it needed to keep the nation's economy pumping, the pulse of our country, without which our nation would collapse upon itself and revert back to Hobbes' state of nature. I don't know if any of you have read the Leviathan, but I assure you this is a bad thing. There is another, as of yet, unaddressed point. I ask of you, which case can say that reaches beyond the U.S. borders? One notices that the Commerce Clause covers not only state-to-state trade, but international trade, expanding Gibbons v. Ogden's influence to any nation that the U.S. trades with. With this in mind, one notes Gibbons v. Ogden as an international influence, not just national, something the other two cases can certainly not say. These are the points that compel me to assert that Gibbons v. Ogden is the most influential court case of U.S. history. Thank you for your time.